Hello, this is Matt on the Moon Family Sedan channel. There are people, including attorneys on this planet, who think more likely than not the SEC is going to defeat Ripple in this lawsuit. And attorney John Deaton thinks that the people who are thinking in such a way perhaps have too much confidence in the SEC's actual chances of defeating Ripple. And in no small part, that has to do with the fact that, frankly, the SEC has done a terrible job in applying the Howey test to XRP. I mean, they quite literally don't state what the common enterprise is, which is a prong of the Howey test. And unless you satisfy all prongs of the Howey test, you don't have a case. You can't just, find that two prongs total apply. Because even if they did, again, you have to have all the prongs of the Howey test here. And when it comes to common enterprise, the SEC literally is no longer asserting what that is. And so attorney Deaton points out in some new comments the degree to which this should be catastrophic for the SEC's chances in actually defeating Ripple. Now, even though I completely agree with what attorney Deaton is saying here, it's always possible that we get a wacky, terrible, unjust ruling in the SEC v. Ripple case, but I don't see how it's possible that the judge, in this case, Judge Torres, could grant the SEC's motion for summary judgment defeating Ripple. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so here's what Attorney Deaton had to say just yesterday. Common enterprise is a real problem for the SEC in this case, and XRP holders, as amici curiae, have contributed a lot on the issue. Remember, initially the SEC argued that Ripple was the common enterprise. Two things then happened. Number one, Ripple forced the SEC to admit that owning XRP gives XRP holders zero rights or interest in Ripple, and Ripple owes XRP holders absolutely nothing. Pause note. That is a major failure on the SEC's part. And ceding that ground, absolutely astonishing. And then Attorney Deaton says, and number two, XRP holders became amici a year and a half before anyone else filed an amicus request, and we submitted 3,000 affidavits stating that the majority of first-time purchasers of XRP were unaware of the company Ripple. Thousands acquired XRP for non-investment reasons. Now, folks, that's always been astonishing to me, and this is just cold, hard fact. Sworn affidavits from actual XRP holders stating, like, they don't have any, they don't even know where Ripple existed. And so, again, let me read that one more time. XRP holders became amici a year and a half before anyone else filed an amicus request, and we submitted 3,000 affidavits stating that the majority of first-time purchasers of XRP were unaware of the company Ripple. Thousands acquired XRP for non-investment reasons. We received financial benefits from XRP completely independent of Ripple, and we utilize XRP as a substitute for fiat, to name a few of the things we proved to the court. And so I'll just say, I don't know how you could possibly be in a common enterprise with an entity if you don't even know they exist. But again, the SEC did at least back off that argument. Ripple's not the common enterprise, but what is? Well, let's keep going forward here. Attorney Deaton then says, we also challenged its so-called expert witness hired by the SEC to issue a report about XRP holders. Oh, my friends, I absolutely love this. Check this out. At the deposition of this so-called expert, he/she was shown a Twitter thread of mine during cross-examination by Ripple lawyers. I attached all of this to the amicus brief I submitted it to the court. This alleged XRP holder expert backtracked when confronted with the Twitter thread. This so-called expert testified on cross that his/her opinion may have been different if he/she had been aware of the claims and evidence being submitted by me and my 75,000 friends. So, folks, right here, this is another instance of complete and utter devastation for the SEC. This is a major expert witness. Thought they had a pretty solid argument there. And then, upon this information being brought to light, the expert backtracked entirely, substantially harming the SEC's case. You have to love this stuff. Anyway, Attorney Deaton continues. Because of what we submitted, and Ripple lawyers forcing the SEC to concede XRP provides no interest or rights in Ripple, this so-called expert argued the common enterprise wasn't Ripple after all, but the entire XRP ecosystem, which includes all XRP holders and all exchanges. Ripple filed a Daubert challenge to this expert. And so maybe you guys will recall at this point, but just in case you don't, a Daubert challenge is just a challenge that's issued against an expert witness in a case, and it could be because you could argue that they're not sufficient, they're not actually a legitimate expert for reasons A, B, C, 1, 2, 3, or you can state that the information that they're providing, the methodology used to present the information, whatever it may be, is just flawed. So there are a couple different ways that can go down. So Ripple did file a Daubert challenge against this particular expert who ended up backtracking here. And this is after, acknowledging Ripple's not the common enterprise, it's the entire ecosystem. And can you imagine claiming that with any other thing that exists? Think about gold. I love this comparison. Imagine if a gold miner was in a common enterprise with everybody else that just has a common interest in gold, like like a jeweler, anybody in the world of fashion, or an electronics company that uses gold in the manufacturing of electronics products. Just because there's a common interest, there's now a common enterprise? Well, no, of course not. That's not the legal standard. But that's what is being argued with the XRP ecosystem. Oh, anything that touches it. This wouldn't fly applying it to anything else, and it sure as hell doesn't with XRP either. But anyway. Attorney Deaton continues. Ripple filed a Daubert challenge to this expert. I filed a request to also comment on this expert, considering he/she issued this report without interviewing a single XRP holder. That's one of the most amazing things about this. How did they think that this was going to go well for them? They didn't talk to a single XRP holders, but then this expert asserts that they know why XRP holders hold XRP. What in the ever-loving hell is that? That's some weak sauce right there, my friend. And then Attorney Deaton says, the judge denied my initial request, but said I could reapply later if this expert's testimony was used for summary judgment. But the SEC abandoned its so-called expert. In its summary judgment brief, the SEC didn't rely on or cite to anything this alleged expert said. That's right. My friends, Ripple's attorneys destroyed this expert witness. So they just threw the expert to the side. Discarded. Which probably, was the best thing that they could have done in those circumstances, but utter devastation for them. I absolutely love it. And so then Attorney Deaton says, therefore I ask, what is the common enterprise? It can't be Ripple, and since the SEC abandoned its expert, there is no XRP ecosystem testimony before Judge Torres. If you carefully read the SEC's brief, it claims XRP is the common enterprise itself. It actually says it. But guess what? The SEC also claims that XRP itself represents all the promises and inducements and efforts made by Ripple since 2013 until the present. Do you realize what this means? It means the SEC is arguing XRP itself satisfies both the second and third prongs of Howey. The SEC literally claims XRP itself was, is, and always will be a security. Read this section of the amicus brief I filed and how I show, quote, the scope of the SEC's Howey argument has become so stretched that it is truly indefinable in space or in time, end quote. Yeah, I love that line, by the way. And just for the sake of time, I'm not going to read this, but for those of you that are looking at your screen, if you want to pause right here, this is one of two screen grabs, and then I'm going to switch to the second one now, and you can pause here as well. But just through context and what Attorney Deaton says in this thread, it's technically sufficient, but I've covered the entire amicus brief, so again, just for the sake of time, I'm not going to read that, but you have the option to check it out if you want to. And so then Attorney Deaton wraps up by saying, that's not how a Howey analysis works, and it certainly doesn't make a token itself always a security, no matter the circumstances. People predicting the SEC will definitely win and that XRP is doomed are overstating the SEC's chances. The SEC's allegations are stretched too far. So there you go, my friends. So when it comes to the common enterprise, the SEC is in trouble here because they don't like come outright and state here it is as it applies. I mean, what they argue, and I think what Attorney John Deaton was getting in here, is they do argue that the totality of the scheme, and I've covered that so many times for like the last year and a half, that's the totality of the scheme, and I'm paraphrasing here, of course. It's all the participants within the ecosystem. They do make those types of arguments. They just don't explicitly state they don't say it like this. Here's what I'm trying to get at. Here's the point. They're not stating that everything in the ecosystem, they're not like that anyway, that everything in the ecosystem that touches XRP is the common enterprise. That's not how they word it. So if you look at what they're actually arguing, though, that is effectively what they're arguing. That's the idea that I was trying to get across there. So what's the common enterprise? It's not Ripple, it's just everything. And so if you're the judge, how do you see that argument and think, yes, there's even a small fraction of a percent of a chance that I grant the SEC's motion for summary judgment, meaning that they win? How can you even do that when the Howey test, the arguments clearly aren't satisfied? So again, we'll see. And the other thing that bothers me too, well, there are a lot of things, but this thing just popped in my head. The SEC never cites specific transactions, which is historically precedent in terms of precedent. That's a requirement. You have to name specific transactions to be analyzed when you're making a claim, but instead, the SEC never does. They just say every transaction. Not specific transaction, every single transaction. Oh, okay. Well, that doesn't make any damn sense, and that's not how this is supposed to work. I don't see. And so that's why it's like, fine. I'm not the attorney. I get it. And there are attorneys that actually think it's more likely that the SEC wins. I don't get how, though. I acknowledge we could have a bad ruling, but again, I just don't see how it makes logical sense. And so I think Attorney Deaton makes a rather salient point here by concluding ultimately the people that think that the SEC might have the upper hand here, perhaps they're overstating the SEC's chances. And that's what it looks like to me. So we'll see what happens. Of course, even if we do get a bad ruling on that front, as long as XRP is allowed to continue to exist and be traded in the United States on secondary markets, I'll consider that a win for XRP holders regardless of what happens to Ripple. I'm concerned mostly about the XRP community before Ripple. I'll say that. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. So that would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.